So today we look at a High Court case. This is one of the interesting cases, especially when it comes to contract management, specifically contract interpretation. So this case has to deal with Transnet. Transnet is a state-owned enterprise in South Africa. They mainly deal with logistics. Transnet versus Spilltech. So Spilltech is a service provider to Transnet. Spilltech in this case put forward a claim for 117 million because Transnet allocated the works which were supposed to be allocated to Spilltech to others. But the main source of the dispute or the main source of the case had to do with misinterpretation of the contract. Now, the contract signed between Transnet and Spilltech was an NEC 3 term service contract. Now, you will understand that term service contracts will mostly have the wording as and when required, the same with this specific one. That was the main contention in this case. Now, if we just look at the scope of work, it says responding to emergency and remediation of environmental incidents for major spills which are above 50,000 liters at Transnet pipeline, as and when required. I need you to underline that part, as and when required, because that was the main issue for a period of 3 years. That's the scope, right? Now, when it comes to interpretation, Transnet has its own version, Spilltech has its own version. So according to Transnet, as and when required meant that Transnet can give the works to other service providers, meaning even when there are spillages above the 50,000 liters, Transnet can choose, or the contract allows them to choose to give the works to any other service provider. That's the interpretation according to Transnet. Now, Spilltech disagrees with that. According to Spilltech, they have exclusive right to any of the spillages which are above 50,000 liters. Meaning, Spilltech understands that if the spillage is less than 50,000 liters, Transnet can give the works to others. But the minute the spillage becomes more than the 50,000 liters, the works must come to Spilltech. That's the understanding from Spilltech. So the two are on two opposite sides. Transnet says I can give the works to any other, even if it's above 50,000. Spilltech says no, if it's above 50,000, the works must come to me. Now, in this specific case, Transnet did proceed to issue work to another service provider. That's where the matter started. So the process they followed was they first tried to discuss the matter internally. It did not work. Spilltech then issued a dispute adjudication process started. The adjudication process decided or issued a decision to say Transnet was correct. According to the adjudicator, Transnet's interpretation was correct to say as and when required meant they can give the works to others. Now, Spilltech disagreed with the adjudicator's position, and then Spilltech took the matter to arbitration. And then the arbitration ruled in favor of Spilltech, where the arbitration said Spilltech was entitled to 117 million for loss of income as a result of Transnet giving the works to another service provider. Now, Transnet was not happy with the decision from the arbitration, so Transnet made an application in this case to the High Court. So Transnet in this case are the applicant, and Spiltech in this case are the respondents. Now, the High Court looked into the matter because Transnet requested the High Court to set aside the arbitration decision which said Spiltech is entitled to 117 million due to Transnet giving the works to others for loss of income. Now, the High Court also ruled in favor of Spiltech. So the High Court supported or upheld the decision from the arbitration to say Spiltech's interpretation is correct, to say as and when required in this term services contract meant that any spillage which is above 50,000 liters had to be issued to Spiltech. Now, that's the decision that came out of the Gauteng High Court upholding the arbitration decision, and Transnet lost the case. Now, what are the lessons or what are the takeaways that we can take from this specific case, especially for you as an employer, team, or especially for you if you are in the contractors team, as an entrepreneur or as a professional? What are the key lessons? There are three. The first one I want us to look at is Transnet, because they are the ones who were setting up the project. They could have decided from the onset not to give the work only to Spiltech. So Transnet could have opened this specific scope to a panel. In that way, if they had a panel and they had other service providers whom they can choose as and when the work came about, then there would not have been the issue to say they are going outside of the contract or they are in breach of the contract, because in this specific case, they only gave the works to Spiltech. But if from the beginning they knew that we want flexibility, we want to use other service providers, then they could have taken the approach to say, let's create a panel for the scope so that we have flexibility to choose whomever we think we want. So hopefully in the future, that's what Transnet will look into doing, but also in your specific contracts that you are currently drafting, if you know that or if you can foresee that for a certain scope, you might need the flexibility to use others, then rather choose a panel for the services that you want. Because if you lock it with one supplier, then you have to use that one supplier. But while you are at the beginning, you can choose, you can set the rules of the game from the start. So for me, Transnet missed it at the beginning. They could have placed the contract not with one supplier, but a number of suppliers under a panel contract. The other one is clear terms. As and when required is used mostly in the term services contract. But if in this specific one, the expectation was that it should be understood differently, then it should have been defined in that manner to say, As and when required here also means that we can choose to use other people. So a clear definition of that wording needed to be introduced into the contract so that at the beginning Spiltech knows that we are signing this contract with you as and when required for 3 years, but also note as and when required according to us means that we are open to use other service providers. So this could have just been defined clearly. Then the last part is to say communication. If from the start, Transnet, when they started to see that they now want to use others, then they approached Spiltech and had open communication or understanding around as and when required, or this which they are trying to do, then things could have been different.